If you've been working in the United States, paying into Social Security, contributing to the system, building a life here, there are 3 Supreme Court decisions that directly affect your retirement benefits, your legal status protections, and your financial future in this country, and one of them just came down on March 4th, 2026, 9-0, unanimous. Now, I know what you might be thinking, Supreme Court cases, that's for lawyers, right? That's complicated. That doesn't touch my daily life. But I need you to stay with me for the next few minutes because what I'm about to break down affects asylum seekers, green card holders, people on work visas, naturalized citizens, and long-term residents who have been building their retirement here in America. If you or anyone you know has contributed to the U.S. Social Security system or is planning to, this update is not optional watching. This is essential. Let's get into it. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand, without the panic, without the rumor, and without the political noise. Before we go any further, I want to be transparent with you, as I always am. I am not your attorney, and this content is for educational and informational purposes only. Nothing I say in this video constitutes legal advice for your specific situation. Every immigration case is unique, and I always encourage you to consult with a licensed immigration attorney before making any decisions that affect your legal status. What I can do, and what I do every single week on this channel, is give you the factual foundation so that when you do walk into that attorney's office, or when you do file that application, you are not walking in blind. Today we are covering 3 interconnected Supreme Court decisions. One is brand new, one came out of 2025. And one that most people have forgotten about, but that forms the legal backbone of your retirement benefit rights in America. Together, these 3 cases tell a story that every immigrant in this country needs to understand. Let's start with the freshest one. March 4th, 2026. The Supreme Court handed down its decision in the case of Urias-Orellana versus Bondi. 9 justices, 0 dissents, unanimous. Justice Ketanji Brown Jackson wrote the opinion, and while the legal language is technical, the practical effect is something every immigrant in the asylum or benefit system needs to hear clearly. Here is what happened. The case involved an immigrant who made claims related to persecution, the kind of factual and legal arguments that come up not just in asylum cases, but in cases involving eligibility for certain federal benefits. The question before the court was this: when an immigration court reviews a decision made by the Board of Immigration Appeals, which we call the BIA, how much weight should that court give to what the BIA already decided? And the court ruled 9-0 that federal courts must give significantly greater deference to BIA factual and legal determinations. In plain English, what that means is this: if the Board of Immigration Appeals has reviewed your case and made a finding, whether about your credibility, your claimed persecution, or your eligibility status, it is now considerably harder for a federal court to overturn that finding on appeal. Now, why does this matter for retirement benefits? Because here's where this becomes critical. Many immigrants who apply for federal retirement-related benefits, including supplemental security income, certain Social Security programs, and other federally administered programs, run through a legal eligibility determination process. That process involves factual claims. Claims about your history in the United States, your contributions, your status, your timeline. And in cases where an immigrant's status has been questioned or adjudicated at any point before the Board of Immigration Appeals, this ruling now means that those earlier BIA determinations carry more legal weight. If the BIA found something unfavorable in your record, even years ago, even in a case that seemed unrelated, a federal court reviewing your benefits eligibility now has a much higher bar to correct that determination. That is a significant shift. And importantly, this ruling does not just affect asylum seekers, it affects any immigrant whose immigration history has touched the BIA. If you've had any removal proceedings, any appeals, any administrative hearings, this decision affects the legal landscape around your case. The action item from this case is straightforward but urgent. If there is anything in your immigration history that was decided at the BIA level, anything that was found against you, anything that was ambiguous, you need to speak to a qualified immigration attorney now, not later. Now, because the window for correcting those records through federal court is effectively narrowing. Now let's move to the second case, and this one, I want you to pay very close attention to because it affects something you may not have thought about in a legal context, your Social Security earnings record. In 2025, a case involving the Social Security Administration and the American Federation of State, County, and Municipal Employees, AFSCME, came before the court in the form of an emergency application. The case, docketed as 24A1063, dealt with one specific and deeply important question. Could the Department of Government Efficiency, the executive initiative commonly known as DOGE, access Social Security Administration records, including personal earnings records, for federal audit and efficiency review purposes? The court's response came in the form of an emergency order that effectively allowed a framework for that access to proceed under controlled conditions. And while the full constitutional litigation on this issue is still unfolding in lower courts, what the Supreme Court's posture signaled, and what the broader federal landscape now reflects, is this. Your Social Security data is no longer siloed in the way that many immigrants assumed it was. Here is why this matters for immigrants specifically. Your Social Security earnings record is tied directly to your retirement benefit calculation. Every year you've worked in the United States, every employer who reported your wages, every quarter you've contributed, that is all in your SSA file. And for immigrants, that file often contains information that indirectly reflects immigration status transitions. A name change tied to a naturalization. Earnings from a period when a work authorization was in effect. Gaps that correspond to periods outside the country. Now, I want to be careful here and precise because this is where many commentators get it wrong. This case does not mean that your Social Security retirement benefits are being taken away. It does not mean that federal auditors are reviewing your file right now looking for immigration violations. That is not what this ruling established. What it does mean is this. There is now a legal framework being established, still contested, still evolving, under which federal executive agencies may access SSA data for administrative purposes. And for immigrants who have complex status histories, who have had periods of authorized and unauthorized presence, who have work records that span different immigration categories, this creates a new layer of exposure that simply did not exist at this level before. This is what many green card holders are misunderstanding. They assume that because they are now lawful permanent residents, their past history is sealed off from future review. Under the pre-2025 framework, that assumption had more grounding. Under the framework that is currently being litigated and shaped by decisions like this one, that assumption is less safe. What should you do about this? Step 1. Request your own Social Security earnings statement. You can do this at ssa.gov. Review it carefully. Make sure every employer, every period of earnings, every reported wage is accurate. Discrepancies in your SSA record can create complications not just for your retirement calculation, but for your immigration record if that data is ever cross-referenced. Step 2. If you have any gaps, errors, or concerns in that record, consult both a Social Security specialist and an immigration attorney, because correcting SSA records and understanding their immigration implications requires expertise from both fields simultaneously. Now, I want to take you back to a case that most people have forgotten about, but that I consider the legal foundation of everything else we've discussed today. Dawson versus Steager. This was a unanimous Supreme Court decision, again, 9-0, that established a principle that sounds almost obvious when you hear it stated plainly, but that had to be fought for all the way to the highest court in the land. The principle is this. The United States government cannot discriminate in the distribution or taxation of retirement benefits based on the source of that employment. In other words, the question of whether you receive full retirement benefits and how those benefits are taxed cannot legally depend on who your employer was or what system you worked under. It must depend on what you contributed. Visual. Simple equation graphic. Contribution plus eligibility. Benefit, not source of employment. Now, for immigrants, the application of this principle is powerful. Here's the scenario I want you to think about. Imagine an immigrant worker. Let's call her Maria. Maria came to the United States on an H-1B visa 16 years ago. She became a lawful permanent resident 8 years ago. She naturalized 5 years ago. For all 16 of those years, she has been paying into Social Security. FICA taxes taken out of every paycheck. Medicare contributions, all of it. Now Maria is approaching retirement age, and she starts hearing things from well-meaning friends, from internet forums, from people at her place of worship, that immigrants don't get full Social Security benefits, that her benefits might be calculated differently, that there's some rule that penalizes people who weren't born here. That is not the law, and Dawson versus Steager is part of the legal architecture that makes it not the law. What this ruling affirmed is that retirement benefit determinations must be based on contribution and eligibility, not on the pathway through which you entered the workforce, not on the national origin implications of your employment history, and not on any classification that functions as a proxy for where you came from. However, and this is the detail most people are missing, this protection is not automatic in its application. It must be claimed, it must be understood, and it must be protected through proper documentation. If you have gaps in your Social Security contributions because of periods of unauthorized presence, because of international work assignments that weren't properly reported, or because of employment under different names or Social Security numbers at different points in your history, those gaps will affect your benefit calculation. And unlike a discrimination claim, gaps in the record are simply gaps. The law protects you from discriminatory treatment. It cannot protect you from an incomplete record. I want to bring all three of these cases together through one story, a composite, a hypothetical, but one built from the kinds of situations that immigration practitioners see regularly. Meet Carlos. Carlos came to the United States from El Salvador in 2001. He entered without authorization, worked construction for 7 years, paid taxes through an ITIN, and contributed to Social Security through those payments, not under his own name, but contributions were made. In 2008, he qualified for a program that allowed him to adjust his status. He became a lawful permanent resident. He started working legally under his real name. In 2015, he naturalized. He has now been a U.S. citizen for over 10 years. Carlos is 61 years old. He's thinking about retirement. He goes online to check his Social Security statement, and he notices something alarming. His earnings record only goes back to 2008. The 7 years of contributions before that? They're tied to a different Social Security number that was used during his undocumented period. They're not showing up under his legal record. Here's what Carlos is facing across all three cases we've discussed today. Under Urias-Orellana versus Bondi, if there was ever any BIA proceeding in his history, even something from 2003 or 2004 that seemed resolved, that record now carries greater legal weight and could complicate any federal administrative review of his benefits. Under the SSA data access framework being shaped by the 2025 litigation, if a federal review of SSA records were to identify discrepancies in Carlos's earnings history, that could trigger an administrative inquiry that touches both his benefits calculation and potentially his naturalization record. And under Dawson versus Steager, Carlos has the legal right to ensure that contributions made on his behalf, regardless of the source, are considered in his benefit calculation. But exercising that right requires documentation. It requires legal advocacy. It requires someone who knows how these systems intersect. Carlos is not a fictional tragedy. Carlos is a common story. And the message of all three of these cases taken together is that the law provides protections, but those protections require engagement. They require documentation. They require professional guidance. So what do you actually do with all of this information? Let me give you a clear, structured action plan. 5 steps that I would recommend to any immigrant watching this video right now. Step 1. Request your Social Security earnings statement immediately. Go to ssa.gov and create a My Social Security account if you don't have one. Download your full earnings history. Review every year. Look for gaps. Look for discrepancies. If something doesn't look right, write it down, because we're going to address it. Step 2. Pull together your complete immigration timeline. Every status you've held, every visa category, every application you've filed, every date of entry and exit. If you have had any proceedings before an immigration judge or the Board of Immigration Appeals at any point in your history, identify those and locate the documents. Step 3. Cross-reference your immigration timeline with your Social Security record. Are there earnings reported from periods when you didn't have work authorization? Are there gaps during periods when you were legally working? These intersections are where complications arise, and identifying them now, proactively, is far better than having them surface during a benefits claim or an administrative audit. Step 4. Consult a qualified immigration attorney and a Social Security benefits specialist, ideally someone who has experience with both areas, or 2 professionals who can coordinate. The intersection of immigration law and Social Security law is not a place for generalists. It requires people who understand how these systems talk to each other. Step 5. Do not rely on unofficial sources, not immigration forums, not social media, not well-meaning friends. The landscape right now is changing rapidly, and misinformation in this space doesn't just lead to bad decisions, it can lead to irreversible ones. Now let me step back and give you the bigger picture, because understanding where we are right now in immigration policy requires some context. What we are seeing in 2026 is a convergence of three forces that are reshaping the legal landscape for immigrants in America. The first is an executive branch that is using administrative and data infrastructure in new ways. The SSA Access Framework is one example of that. The second is a Supreme Court that has consistently, across a range of cases, shown deference to administrative agencies and executive determinations in immigration matters. Urias-Orellana is the most recent example, but it fits a pattern. And the third is a benefit system, Social Security, Medicare, federal retirement programs, that was designed in an era when immigration complexity looked very different from what it looks like today. The legal challenges to the SSA Data Access Framework are still working their way through the courts. There is no final resolution. There is no settled law that tells us exactly how far that access extends or what its implications will be long-term. What we know is the direction of travel, and that direction requires immigrants to be more proactive, more documented, and more legally advised than at any point in recent memory. The good news, and there is good news here, is that the foundational protections established by decisions like Dawson versus Steager are solid, 9-0, built into the legal architecture of this country. Your contributions matter. Your eligibility is not determined by where you came from. Those principles are not being overturned. What is changing is the complexity of the environment in which you have to assert those principles. This protection may not be permanent in its current form, not because the law will be reversed, but because the administrative infrastructure around it is evolving, and that evolution requires your attention. Before I close, I want to take one moment to remind you why any of this matters. Because sometimes when we talk about court cases and administrative law and Social Security records, it can feel abstract, distant, like it belongs to a world of bureaucrats and attorneys and federal buildings, but here is what is actually at stake: your retirement security. The ability to stop working one day and know that the contributions you made for decades in this country will come back to you in the form of benefits you earned. Your family's financial stability, because your retirement affects not just you, but your spouse, potentially your dependents, potentially the family members in other countries who may rely on your economic foundation. Your residency and citizenship status, because in a legal environment where data is increasingly cross-referenced and administrative records carry more weight than they once did, an unaddressed discrepancy is not a minor inconvenience. It is a vulnerability. You built something here. You contributed to this country's economy, its tax base, its Social Security trust fund. The law, at its foundation, recognizes that contribution and promises to honor it, but the law only works for you if you engage with it, if you understand it, if you protect your record and assert your rights with proper guidance. That is what I am here for. That is what this channel is here for. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. If this video helped you understand something that you didn't fully understand before, please leave a comment below and tell me your visa category or your immigration situation. Not for legal advice, but because it helps me understand what topics to cover next, and it helps other people in your situation know they are not alone. Share this video with someone who needs to hear it, a family member, a coworker, someone who's been in this country for years, paying into the system, and has never once thought about how these court decisions affect their future. That share could make a real difference in someone's life. And hit the like button, not for me, but because it tells YouTube that this kind of factual, careful immigration analysis deserves to reach more people who need it. I'm Raymond Crivello. Stay informed, stay protected, and I'll see you in the next one.